subscribe to our channel and press the bell icon to never miss a video from Live Law.
Hey guys, welcome to Courts This Week. We are in week 3 of September 2020 and developments in courts saw the restraining of Sudarshan TV show with the tagline UPSC Jihad, some important top court judgments and Umar Khalid's 10-day remand order, among others. So let's begin with the Supreme Court first. You cannot target one community and brand them in a particular manner. Top court restrained Sudarshan TV News from telecasting its show on UPSC Jihad on the alleged infiltration and conspiracy of Muslims in the civil services till further order. During the hearing, the bench led by Justice D.Y. Chandrachud called the show an insidious attempt at maligning a community, adding that this cannot be tolerated in a free and democratic society. While the channel justified the show, claiming it was a part of investigative journalism, denying vilification of Muslims, Justice Chandrachud said, "As a Supreme Court of the nation, we cannot allow you to say that Muslims are infiltrating civil services. You cannot say that the journalist has absolute freedom doing this." Now, arguments are ongoing in this case and they will continue on Monday, that is tomorrow. Advocate Prashant Bhushan has moved the Supreme Court seeking review of the contempt verdict passed against him by a bench led by Justice Arun Mishra for his remarks over CJI and functioning of the Supreme Court, adding that defense of fair comment has been ignored by the court. Mr. Bhushan has also cited various instances suggesting that Justice Mishra's presence on the bench raised reasonable apprehension on his part of getting a fair and impartial hearing. Bhushan also paid in full the fine of ₹1 imposed upon him by the top court on Monday. While doing so, he had stated that even though he is paying off the fine, it does not mean that he has accepted the judgment, which held him in contempt of court for 2 of his tweets against the CJI as well as the judiciary. Top court shall deliver judgment on the plea challenging the conduct of the separate examination by the National Law School of India, Bangalore, on Monday, that is tomorrow. A bench of Justices Ashok Bhushan, Subhash Reddy and M.R. Shah conducted a full-fledged hearing in the plea this week, filed by former Vice Chancellor of NLS-IU, Professor R.V. Rao, and an aggrieved law school aspirant challenging the sudden withdrawal of NLS from the Common Law Entrance Test 2020 and its decision to hold a separate National Law Admission Test NLAT. Note that even though the court had restrained NLS from declaring results and consequent admissions for the academic year 2020 to 21, it had allowed the university to conduct the exam on September 12 as scheduled. University has also said that any malpractices which were observed during the conduct of the exam shall be a reason to disqualify the students. Notice has been issued in a plea challenging provisions of the Special Marriages Act 1954 insofar as they require the parties to the marriage to establish their private details open for public scrutiny before 30 days of intended marriage. The petitioner Nandini Praveen, a law student, has challenged Section 6.2, 7, 8 and 10 as well as Section 6.3 to the extent to which it says that marriage officers shall thereupon cause a copy thereof to be affixed to some conspicuous place in his office, and Section 9 to the extent of dealing with the inquiry. Supreme Court has declined to vacate a stay earlier granted by Delhi High Court towards the ongoing IBC proceedings against Reliance Group Chairman Anil Ambani. The bench asked SBI to complete proceedings before the High Court and seek modification as prayed for, adding that the case will be taken up before the Delhi High Court on October 6. The plea comes in light of an order which was passed by the Delhi High Court staying the IBC proceedings against Ambani in terms of an INR 1,200 crore loan disbursed by SBI. The SBI invoked personal guarantee in terms of the same, but a division bench of the Delhi High Court restricted Anil Ambani from alienating his assets till the next date of hearing. Attorney General K.K. Venu Gopal declined his consent on an application seeking initiation of contempt proceedings against consulting editor of the India Today Group, Rajdeep Sardesai, for his tweets in relation to the Prashant Bhushan contempt case. The rejection of the AG read, Mr. Sardesai's statements are not of so serious a nature as to undermine the majesty of the Supreme Court or lower its stature in the minds of the public. The reputation of the Supreme Court as one of the great pillars of democracy has been built assiduously over the last 70 years. Trifling remarks and mere passing of criticism, though perhaps distasteful, are unlikely to tarnish the image of the institution. I'd like to take you through some important judgments of the top court now. Major unmarried daughter who is not suffering from any physical or mental abnormality shall not be entitled to claim maintenance from father under section 125 of the CRPC, said the Supreme Court. The bench headed by Justice Ashok Bhushan held that unmarried Hindu daughter can claim maintenance from her father till she is married, relying on section 23 of the Hindu Adoptions and Maintenance Act, provided she pleads and proves that she is unable to maintain herself. This enforcement of her right will emanate from an application or suit which will have to be filed under section 20 of the Act. Supreme Court order extending limitation period does not enlarge the period up to which delay can be condoned. In exercise of statutory discretion, clarified the Supreme Court. The court held that the expression prescribed period appearing in section 4 of the Limitation Act cannot be construed to mean anything other than the period of limitation. Section 50 of the NDPS Act is applicable only in the case of personal search, the Supreme Court has reiterated while affirming the conviction of an accused. The bench referred to a 3-judge bench judgment in the state of HP versus Pawan Kumar, which considered the issue whether the safeguards provided by Section 50 of the NDPS Act 1985 regarding search of any person would also apply to any bag, briefcase, or any such article or container, etc., which is being carried by him. The accused was a temple priest, and the court noted that the charas was found in the counter of the dhaba in a gunny bag, which was constructed on the land owned by his wife near the temple. The facts of the case show that the accused not only had direct physical control over the charas, he had the knowledge of its presence and character, the court said. High courts and other courts now. In the ongoing controversial case of Kangana Ranaut's home demolition by BMC, an affidavit has been filed by the government body stating that Ranaut is misleading court and that she has not even denied brazenly making illegal alterations and additions against the sanction plan. Note that last week, the Bombay High Court directed the Brihan Mumbai Municipal Corporation to stop the demolition being carried out by the civic body at actor Kangana Ranaut's house in Pali Hill, Bandra. The BMC has now also denied the allegations of premeditation and malice against Ranaut. The Bollywood actress has found herself in another legal row when the Punjab and Haryana High Court dismissed a petition seeking action against Kangana Ranaut for putting out a Twitter post allegedly to promote the consumption of beef. Kangana's tweet read, "There is nothing wrong with eating beef or eating any other meat. It's not about religion. It's not a hidden fact that Kangana turned vegetarian 8 years ago and chose to be a yogi. She still doesn't believe in just one religion. On the contrary, her brother eats meat." Court noted that the perusal of the alleged social media post does not prima facie suggests that it amounts to commission of an offence punishable under section 295A of the IPC. On the contrary, the post describes the person as a vegetarian, therefore it cannot be construed at all that it promotes consumption of beef, much less by way of advice. Delhi High Court has issued notice in a plea moved by an advocate challenging issuance of challan against him for allegedly not wearing a mask while driving his car. Filed by advocate Saurabh Sharma, the petition challenges the challan of Rs 500 issued by Sub-Divisional Magistrate of East for allegedly not wearing a mask in public place. The Patna High Court has asked the state government to think about enhancing the economic support to the members of the transgender community who at this point in time are suffering acute hardship, more so on account of the nature of activity to which they are engaged in. The division bench of Justice Sanjay Karol and Justice S. Kumar issued this order in a petition highlighting the pitiable state of affairs of the transgenders in the state. Allegedly, the community is ostracized more so in times of the current outbreak of the coronavirus pandemic. The special CBI court at Lucknow will deliver on September 30th the verdict in the criminal case related to the conspiracy behind the demolition of Babri Masjid Mosque in 1992. Prominent BJP leaders L.K. Advani, Kalyan Singh, Uma Bharti, Murli Manohar Joshi, etc. are the accused in the case. The special judge, Mr. Surendra Kumar Yadav, has asked the accused persons to be present in the court on September 30th for the pronouncement of the judgment. A Delhi court remanded JNU student Umar Khalid, who was arrested around 1 a.m. on September 14, to 10 days of custody of the Delhi police in relation to alleged conspiracy behind the Delhi riots. The Delhi police has sought 10 days of police custody to confront Umar Khalid with huge technical data of more than 40 GB to unearth the deep-rooted conspiracy behind Delhi riots. The police alleged that Khalid had hatched a conspiracy along with several groups to appeal to various Muslim minority groups to block the roads and public places in Delhi during the visit of President Donald Trump. A Delhi High Court convicted Sri Lankan Airlines manager for outraging the modesty of a subordinate employee. The conviction order against the accused Lalit D. Silva was passed on the basis of sole testimony of the prosecutrix, a sales executive at the airlines, after the court observed that her testimony had been thoroughly consistent. The complainant had accused Mr. Lalit of asking her inappropriate questions that intruded upon her privacy. Accordingly, an FIR was registered under Section 509 of the IPC for outraging the modesty of a woman. So that's all for this week, guys. I hope this was informative. Until next week, but don't forget to hit the like and share button. See you.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.